it seems to me to be impossible that having absolved our allegiance to the king, which is something that is impossible under the British
law.
Yeah, under the King's law, that we would at the same time adopt birthright citizenship as the basis for citizenship in America.
Ed, you've written a lot about immigration, and not simply with a point to make a point about the contemporary disputes, but also to throw it into kind of philosophical and historical context. And in particular, you make an argument which not very many people make these days, and I think you make it very well. That the way we think about the problem of immigration is all mixed up. And it's mixed up largely because we assume what is, I guess, usually referred to as birthright citizenship, that anyone who's born virtually anyone born in the United States of America is automatically a citizen of the United States of America. And I think for many people it would be very hard to think the contrary. Why do you think the contrary, and to what extent do you so think?
The Citizenship Clause of the 14th Amendment is the first time that citizenship was defined in the American Constitution. Citizens and citizenship are referred to in the Constitution, but nowhere defined. You have to be a citizen to be a member of the House. You have to be a citizen to be a Senate. You have to be a natural-born citizen to be President of the United States. Of course, at the time the Constitution was written, there were no natural-born citizens in the United States, so there was an exemption. You have to be a citizen at the time the Constitution was adopted, or a citizen for 17 years, and so on and so forth. As I calculated, I think Martin Van Buren was the first natural-born citizen of the United States.
And if you to become president of the United States.
Yes. And I think if you calculate that the exemption means that you have to have been a citizen at the time that the Declaration of Independence was adopted. So that's the break point. But in any case, prior to the 14th Amendment, the rule was that a citizen of a state was automatically considered to be a citizen of the United States.
So citizenship in a state,
yes,
like Massachusetts or New York,
yes,
took precedence, as it were, over national.
Yes, this wasn't quite the constitutional rule, but it had not been challenged. This was just the rule of practice as it worked its way out over the years.
So to become a citizen of the United States, just to clarify, you would have to become a citizen of New York or of one of the other states.
Yes, exactly, right. Okay. The problem in the beginning, of course, was the problem of free blacks and the questions that were surrounding slavery and the comity clause of the Constitution and so on. So these questions were delicate. They were never provoked directly. But of course, by the time...
I see. So what you mean is that if a freed black became a citizen of Massachusetts, which was possible, would he also automatically become a citizen of, let us say, Georgia?
If he moved to Georgia, he had all the rights and privileges of a citizen of Georgia, and so on and so forth. So these were very delicate questions. Georgia would not accord him all of the privileges and immunities of a citizen of Georgia, and so on and so forth. So these questions were avoided. They came to a head after the Civil War, of course. Now, what happened was that if the basis of citizenship had not been changed, of course, the states that had formerly been in rebellion could have withheld federal citizenship from the newly freed slaves by withholding state citizenship. That would have meant withholding not only federal citizenship, but the benefits of the newly enacted federal civil rights legislation enacted for newly freed slaves. And
so they could, slaves, newly freed slaves, could be free, but stateless,
Yeah, Mississippi,
as it were, and
yeah.
in a way rightless, therefore.
Yeah, Mississippi could have said no descendant of a former slave could ever be a citizen of Mississippi. Therefore, they wouldn't have been a citizen of the United States, would not have been subject to the Civil Rights Act of 1866 or the other Civil Rights Acts that came later as well. So it was imperative that the basis for citizenship be changed. So the 14th Amendment says that all persons born or naturalized and subject to the jurisdiction are citizens of the United States first, and secondly of the state wherein they happen to reside. All right. Now, the Citizenship Clause was the last clause added to the 14th Amendment. It was almost as if it were an afterthought. Benjamin Wade, who is otherwise the author of the language of the 14th Amendment, suggested that the Citizenship Clause read, all persons born in the United States are citizens of the United States. And that suggestion went to the Committee on Reconstruction, the Joint Committee on Reconstruction, which was the primary committee that was responsible for drafting the 14th Amendment. When it came back from the committee, the jurisdiction clause was added. So all persons born or naturalized and subject to the jurisdiction were citizens of the United States and of the state wherein they resided.
And a lot hangs, in your interpretation, on that phrase.
So I began to wonder, why did the jurisdiction clause, why did the Committee on Reconstruction insist upon adding the jurisdiction clause? Why didn't they simply say all persons born in the United States are citizens? And so I read the debates on the Citizenship Clause, and it was presented in the Senate by Senator Jacob Howard, who was a senator from Michigan. And I suspect, although I haven't been able to get the evidence, but I suspect he was the actual author of the Citizenship Clause. Congressman Wade, several years later, said that he had been the author of every single word of the 14th Amendment except the Citizenship Clause. And I think that Senator Howard had actually authorized the Citizenship Clause. Now, when it came to the floor of the Senate, he was asked several questions. He says, what does it mean to be subject to the jurisdiction? And he said, it means owing no allegiance to any other government, owing exclusive allegiance to the United States. Today, we are prone to say, get out Black's Law Dictionary and look up jurisdiction. It means subject to the court of the United States. But this is not what Jacob Howard said. It means owing no allegiance to any other country. Exclusive allegiance to the United States. And why didn't he say
that?
Yes, very good question. And it's one that I'm happy to answer. The Civil Rights Act of 1866 had also specified citizenship because they wanted to make it clear that the newly freed slaves were going to be citizens of the United States. And there was a debate at which Senator Howard also took place. And they were asked, why don't we put allegiance in? Now, he said that allegiance was a term of art under the common law. If you look in Blackstone, and I'll mention Blackstone again in a moment, if you look in Blackstone, allegiance is the basis for British birthright citizenship. And there are several types of allegiance. There's temporary allegiance, those sojourner allegiance, and so on and so forth. And what Jacob Howard said is, we didn't want to put anything in the Constitution that gave any idea that citizenship was based upon the British common law. So they used jurisdiction as a Republican substitute
small
for
r
allegiance.
And big R.
Yes, small r as well as big R,
Right.
substitute for allegiance. And that's what he said.
Yeah.
And it makes perfect sense. Now, another objection that came from the floor of the Senate when Howard introduced the Citizenship Clause was, will this make Indians citizens of the United States? And Howard said no.
Meaning Indians in the sense of
Native
Americans.
Yeah,
Yes,
native
right.
persons. Will this make, not the phrase they use, but will this make native persons citizens? And he said no. They were born in the United States, of course, but they do not owe allegiance to the United States. They owe allegiance to their tribes and not to the United States. They will not become citizens as a result.
So for the same reason that American Indians who are members of their tribes, or let's say foreign diplomats who travel through the country on diplomatic passports are not made citizens by virtue of being in the United States. And even if a foreign diplomat had a child, that child would not ordinarily be understood to become a citizen of the United States.
And
that's what he meant by it.
Yes, but he went further. He said native persons will not become citizens. It will not apply to diplomats and their families, nor will it apply to foreigners who happen to be, sojourners in the country who are foreigners, and so on and so forth. So it was very comprehensive here. That birthright citizenship, as understood by the British common law, would not be a part of American citizenship. Now, one other interesting thing. If you go and look at Blackstone, for example, what is the law of birthright citizenship in Blackstone? The common law of birthright citizenship is really quite shocking. It says birthright citizenship is a duty that you owe to the king. If you're born within the protection of the king, you owe allegiance forever to the king. This is primitive and essential, and it is a duty that can never be put off. So once a British subject, always a British subject. And Blackstone even admits that this is a feudal doctrine that's brought over into the common law, a feudal doctrine. Now, at the end of the Declaration of Independence, say, we absolve ourselves from allegiance to the King of Great Britain.
Right.
Now, it seems to me to be impossible that having absolved our allegiance to the King, which is something that is impossible under the British
law.
Under the King's law, that we would at the same time adopt birthright citizenship as the basis for citizenship in America. Mm-hmm. So citizenship in America is based upon consent and not upon the accident of birth. One other element here. In 1868, this is 2 years after the 14th Amendment has been debated, the Congress takes up a bill called the Expatriation Act. Many of the same people who debated the 14th Amendment are still in Congress debating the Expatriation Act, including Jacob Howard. Mm-hmm. And what they realized was that if we're going to have an amendment defining American citizenship, and American citizenship is going to be based upon consent, then of course we have to have some provision for expatriation, which
giving
means
up citizenship. Yeah.
Giving up citizenship, so that you can give up your citizenship, and we must allow you to leave the country as long as it's not to escape some obligation that you've already incurred, or it's not to escape because of crime you've committed or so on.
Debts.
Now, yes. And so in the debate, I remember I was walking into the library to look up in the Congressional Globe, looking up the debates, and I remember walking up the steps of the library thinking, wouldn't it be great if they mentioned the Declaration of Independence and how birthright citizenship would be incompatible with the idea of consent and so on and so forth. And I said, that would be too much to ask for. And when I got the debates, and that's exactly what happened. They said the idea of birthright citizenship is a feudal doctrine that should be banished from the shores of America once and for all. It is, and this shows you the greater literacy that Congress had in those days. It is a indefeasible doctrine of indefeasible allegiance, which should be banished from our shores forever. It is a feudal doctrine that is incompatible with the principles of the Declaration of Independence, which enshrines consent as the basis of American citizenship. And so I think that that's the final word on what the Citizenship Clause of the 14th Amendment means.
Now, but the problem is 30 years later,
yes,
1898, there's a Supreme Court decision which says the opposite,
yes,
right? And that birthright citizenship is the nature of American citizenship.
Yes.
and a child born to a foreigner in the United States is a United States citizen by virtue of being born
Yes.
here.
Yes.
Now, given that this colossal mistake, from your point of view, at least occurs only a generation later, and that it doesn't seem to have been resisted subsequently, why is it that you think birthright citizenship remains un-American?
Well, I think it remains un-American because it's, first of all, inconsistent with the principles of the Declaration of Independence.
But if you acquire your citizenship by birth you can give it up
Yes.
voluntarily, that's different from
Yeah, of
the
course.
old British
Yeah.
system
Well,
where you're the king's subject, and
Yes.
nothing you can do can change that relation.
That's correct. Well, first of all, in 1883, there was another case that confirmed the idea, and it used to be a doctrine of constitutional law that whatever in the British common law was inconsistent with the principles of the Declaration of Independence was repealed by the Revolution. Mm-hmm. And the case in 1883 stood by those principles. And in that case, a native person had presented himself to an elections officer asking to vote. And the elections officer said, "No, you're not a citizen of the United States." But he said, "I renounce my allegiance to my tribe, and I declare my allegiance to the United States." And the decision was that a self-proclaimed allegiance was not enough, right, since the idea of consent was based upon a social contract. There had to be an offer on the part of the government and an acceptance on the part of the individual person. And the government had not made an offer, so self-proclaimed allegiance was not enough. And so the court said, social compact origins, the Declaration of Independence, and that was a good decision. But in 1898, as you mentioned, in the Wong Kim Ark case, it's a little bit more complicated because Wong Kim Ark's parents were legal immigrants in the United States. They were incapable of becoming American citizens because there was a treaty between the United States and the Emperor of China. Emperor of China did not want to allow his people to come to America and become citizens of America. And so the stipulation was he will allow emigration to the United States with the proviso, right, that they not be allowed to become citizens. And they declared their allegiance to the Emperor of China. That was stipulated. We retain our allegiance. Now, Wong Kim Ark was born in the United States of legal residence. He had left to visit China, and when he came back, immigration officers said, "No, we're not going to let you in because you're not a citizen." So the case went to the Supreme Court, and I think that the Supreme Court made a tremendous mistake by saying that the 14th Amendment adopted the British common law of birthright citizenship. There was a vigorous dissent. The Chief Justice said, "No, the Declaration of Independence is our guidance here. The 14th Amendment adopts the idea of consent as the basis for citizenship," and I think that the dissent had it right. My idea here is...
He was the lone dissenter?
No, it was a 5-4 decision, so it was a very close call. And I think that the majority opinion there simply got it wrong. And one of the ways that one of the very suspicious lines of argument in the majority decision was that the court tried to cover over the idea that in the British common law, there is no mention of citizen. Mm-hmm. There are no citizens under the British common law, by saying that for our purposes, citizen and subject are simply convertible terms. And I remembered an old case by Justice Wilson from an early case where he said, in the United States, there are citizens but no subjects. Right. And I think it was the Declaration of Independence that where the idea of citizenship, there are no subjects in the United States. Consent of the governed translates subjects into citizens, where you're expected to be an active participant in the government and an active participant in the enforcement of rights and obligations and so on.
And we like to think that's still true.
Of course. Yeah. If it isn't, then we have to exert all of our efforts to ensure that remains to be true, or if it's not true, to restore it as much as we can. But after the 14th Amendment, what the Congress did, there was an interesting Senate report in 1870 where the Senate Judiciary Committee was asked to do an investigation. What was the meaning of the Citizenship Clause of the 14th Amendment? And the report said that its principal thrust was to ensure the citizenship of the newly freed slaves, and it was not intended to make citizens of native persons. And thereafter, Congress began to pass legislation inviting members of various tribes, offering members of various tribes to become citizens, if they consented, become citizens of the United States. And I believe that they were using Section 5 powers under the 14th Amendment. Section 5 says Congress has the power to enforce the various provisions of the 14th Amendment. Now, this would mean that Congress was taking people who were outside the jurisdiction of the United States and defining them to be within the jurisdiction of the United States if they consented.
Right.
And they did this on a tribe-by-tribe basis until 1923, in which they extended an offer to all native persons in the United States. So I believe today Congress still has that power under Section 5, and they could say that children of illegal immigrants born in the United States are not within the jurisdiction of the United States because their allegiance would follow that of their parents. And I think that the right decision in the Wong Kim Ark case would have been that the allegiance of Wong Kim Ark, being born in the United States, of legal immigrants, would have followed that of his parents. And their allegiance was to that of the Emperor of China. Now, I think the United States could have said that there was an implicit agreement, because they were legal citizens, that Wong Kim Ark, when he became of age, could begin the process of becoming a naturalized citizen and so on. I think that that would be expected. But he would not have been a natural-born citizen. I think that the idea of birthright citizenship was expelled by the Declaration, and the Declaration certainly adopts, the 14th Amendment certainly adopts that point of view.